So good afternoon. My name is Sherman Henry with the University of Oregon Labor Education and Research Center, along with Jennifer Smith and Nikki Rudiger. This afternoon, we're going to have an interesting interactive engagement with Barbara Diamond regarding exploring systemic racism in arbitration. And just to note, the American Arbitration Association reported about 5,738 arbitration cases in 2019. 28% of those cases were discharge cases. 20% of those cases were contract interpretations. 10% of those cases were suspension, and about 7% were discipline, and another 3% were work assignment cases. The American Arbitration Association has a panel of about 682 arbitrators, and 39% of those are also members of the National Academy of Arbitrators. So this is a very interesting practice for those who participate in their union in the grievance arbitration process. And so Barbara Diamond is a former practicing labor side attorney for 35 years in Portland, Oregon, and is now a mediator and arbitrator with Diamond ADR. And so we're pleased to have her this afternoon, to kind of walk us through this process that unions are clearly stakeholders in. And as a result of collective bargaining and arbitration language, we're having an interesting conversation about things that unions can do.
First of all, I want to thank everyone for coming to this conversation today. I have participated in arbitration as an advocate for many years, and I'm starting my practice as a neutral, and I'm very excited about that. But as a result, I have some information to share about what I've gone through to become an arbitrator, and I've explored a little bit about implicit bias in arbitration. So I'll be focusing on that. And we'll also be having some conversations together. So first of all, it looked like the majority of you had actually not participated in a labor arbitration before, but I'm sure most of you know that most labor agreements, if there is a conflict about whether a collective bargaining agreement has been violated, the preferred way to resolve the conflicts under union contracts is to proceed to labor arbitration if the parties are unable to resolve the dispute themselves. So we know that there's a lot of grievance arbitration going on. Unions pay for and support arbitration very significantly. And one of the things that's really interesting when we're talking about bias is that arbitration decisions get enormous deference in our system. Now, even if you have a decision in a court, normally you have the ability to file an appeal to a higher court, and then sometimes even to an even higher court after that. Whereas in arbitration, we know that arbitration awards are generally final and binding. So that's an important factor that makes arbitration, because it isn't reviewed by anyone else, it's kind of, there's not the ability to ask a third party to review whether the decision is right or wrong. Judicial review, when it does occur, is very limited. We also know, though, that in order to become an arbitrator, a labor arbitrator, there's a significant process that a person has to go through. First of all, you have to have quite a bit, at least 10 years of experience, usually more, in the subject matter background, either as an advocate for labor or as an advocate for management. You have to supply a large number of references and annoy your friends by asking them to give you references. And it's a major process. You also have to give up all your work as an advocate to become listed on any of the big listing services. So again, you can't keep working as a union lawyer or a management lawyer, and that's a big ask, and that's before you even get a single case. And we also know significantly that the parties are selected generally from lists by striking by usually the attorneys or the advocates, which is going to become a significant matter when we talk about bias. One of the really significant things about arbitrators which I've learned now in becoming an arbitrator, is the difference. One of the most significant differences in which your chair in the room is very significant. Advocates are very interested in outcomes. You know, unions want to win the case because they think an injustice has been done. Arbitrators are, although I'm sure just the word justice passes their lips, arbitrators are generally more process-oriented, because in a win-lose situation, half the people are going to think the decision wasn't just. So what arbitrators tend to focus on the most is the process. Has everyone gotten a fair hearing? Does everyone feel as though the proceeding has been fair? And that's a really important focus of arbitrators. One of the things that arbitrators are required to commit to as an ethical principle is the notion that you're as willing to rule for the union as you are for management, or you're as willing to rule for management as you are for labor. You have to be impartial. So arbitrators also are subject to a code of ethics, which very much emphasizes the notion of integrity and impartiality. But the code hasn't been updated to deal with the issue of discrimination to any large extent. You can see I took a little excerpt of part of a portion of the code of ethics. It doesn't mention non-discrimination on the basis of sex or race. Perhaps you could argue that it's implied. I would argue that certainly. But really arbitrators are expected, the impartiality is the calling card of an arbitrator. And we know that that's a really important factor. I wanted to, anything in the chat, Jen?
Right now, not yet.
Okay, no, please feel free. And I urge you, if you have a question or comment, to put it in the chat, because we're going to stop periodically so that the chat remarks can be shared, because I want this to be collaborative. So with the background of who gets to be an arbitrator in the sense of what you have to do to become an arbitrator, you can see that right away, the fact that you have to give up your work either for labor or management is a situation that creates the possibility of bias, because who are the people that are better able to support themselves while they go through the laborious process of being chosen from lists? It might tend to be that statistically, if we think that women and people of color in general make less money, which, you know, it's not true of everyone, but it may be true statistically, that may very well be a bias factor that we should examine. But we also know that when we look at bias as a system of decision making that people may rely on, that there are two basic kinds of bias. The first kind of bias is explicit bias, and that we have no trouble seeing what explicit bias is. Basically, those are the attitudes that we consciously believe. In other words, and probably we would hope that everybody here now in this room, in our Zoom room, believe consciously that we don't believe in stereotypes, we don't believe in discrimination, we believe in treating everyone the same. On the other hand, we have the concept of implicit bias, the idea that bias operates unconsciously, and what studies show is that even though we may have explicit egalitarian attitudes, sometimes we have implicit bias which impacts the way that we behave. And in fact, the research tends to show that implicit or unconscious bias is pervasive in decision making. So the question is, and some of you may have taken a class on implicit bias, we know that there's very significant racial bias against Black folks in this country. 80% on the IIT are showing bias against African Americans. We also know that gender bias is very pervasive. And if you're interested in learning more about the different tests for implicit bias, go ahead and Google Harvard Project Implicit, and you'll be able to learn all about what they do. But we do know that in our country that in general, there's pretty significant associations between, preference for white over Black, an unconscious race crime frame that our culture instills in us to associate in particular Black men with crime. Sorts of associations are playing not in our conscious mind, but with what I call the unconscious bias screensaver that goes on in the back of our minds. And it impacts behavior. So let me talk a little bit about how implicit bias with implicit racial and gender bias can work together in arbitration cases. And this would be a question that I would have is, imagine that you've got a case and I've had these cases, that you have a case of a Black grievant who is fired for theft and then denies that they engaged in the theft. In that situation, there is a fairly pervasive bias, unconscious bias that associates Black people with crime and violence. So again, if unconscious bias is going to tip the scale, it's going to be associating this grievant with crime, and therefore be more likely to have someone decide without realizing it, with the impact of implicit bias, that the person is guilty. On the other hand, in my second scenario, if you have a Black female accused of insubordination by a white supervisor and she denies it, we have the combination of both anti-Black bias and particular bias, intersectional bias against Black women, that they're associated with anger or emotion, inappropriate emotion. So there may be those implicit bias stereotypes may very well be in the back of someone's mind. How do you think implicit bias or bias could impact the decision of an arbitrator in any individual case? What I'm going to do is have you be put in breakout rooms and have you discuss those scenarios. You'll be put in a breakout room for about 10 minutes. After you do that, we're going to come back and discuss what you think about those scenarios, whether you agree with me or have other ways of thinking about it. And those of you who've been in arbitration, feel free to share your experiences as well. Please make sure that you introduce yourself to your people in your breakout groups. Please share your pronouns. Mine are she and they. And make sure that you give everyone an opportunity to speak. If for any reason there's an issue in your breakout room, please feel free to come out of the breakout rooms and let one of us or one of the LERC staff know. Okay.
Okay, I'm gonna put you in breakout rooms and we'll have about 10 minutes and hopefully you'll have someone who will be able to report back if asked about what happened in your room. Here you go.
Okay. Let me ask, do I have any volunteers? Anyone about how your group, whether your group came out with any kind of conclusion, or go ahead and under the participant button, if you click on that, you should have a way to share your, to raise your hand. So I'm looking to see if anyone will raise their hand to share out what your group talked about.
I'm ready to go. David,
okay.
I'm ready to go. I'm still learning technology here, so I'm probably not doing it right.
No, go ahead, David.
I was in a group with Barbara and Marissa, and one of the gentlemen who snuck in has sort of snuck back out again, too. Barbara was the only member of the group who had actually done the implicit bias study that Barbara talked about, which is kind of interesting. So it'll be interesting to, for some of us others who haven't done that, Donna's experiences were kind of interesting. Maybe she can speak to those. She's the one who's sort of taken the implicit bias test. We did a little bit, and because I hadn't seen Donna Hammond in a while, we sort of got off the topic, and that was really my fault to discuss some other things since we haven't seen each other in a while. But yeah, we sort of looked at how implicit bias plays a role, particularly with the first example of the Black who's accused of theft. And I pointed out, again, part of this goes to my experience in the arbitration process, that the sense, again, sort of on the street, although we could argue that, is you're innocent until you prove yourself guilty. When in the reality in the workplace, it's the opposite of that. You're guilty until you prove yourself innocent. So there's a sort of an added burden that a Black grievant might face in a case like this. First of all, the fact that he or she is accused, how do they prove innocence? And then add the fact that they're Black and how that might bias how the process goes as well. That's about as far as we got in the conversation. If I miss anything, Marissa or Donna, please jump in. I think I covered it because we moved along pretty quickly.
Okay, how about Amy? I see you have your hand up.
So we had a good conversation in our breakout group. 2 out of 6 of us had participated in arbitration in the past. And one of those shared her experience about presenting 2 arbitrations with union staff in the last year. And one of those, she was a witness in it, and that really opened her eyes to how scary it can be to be a witness in an arbitration. And we didn't get to talk about that much more, unfortunately, but it seems like a good place to make connections to bias and to differential experiences across race and other intersectional lines of diversity. We also, one of us mentioned that they've seen cases in which union members were disciplined and didn't want to go to arbitration because they didn't want to be seen as angry in their work life in the future. And maybe they weren't afraid of formal retaliation, but more of that sort of informal treatment from management. And then we heard that the arbitration panel of the AAA has been called out as not being very diverse, and this body of research on implicit bias really shows why arbitrators need to be more diverse. And arbitrators, we heard, are often from law firms and industries that don't necessarily give you, confidence in their impartiality. And then finally, we had a practicing arbitrator in our group who gave us a little bit of the history of how arbitration has changed from union and management representatives sort of as advocates to lawyering up and having lawyers involved instead. And we didn't get very far in that conversation either.
Okay. What about, I see Elliot has a hand up.
Hi. Yeah, so just really quickly, we also had an arbitrator in our group, and that person mentioned that, they're seeing more and more situations where advocates, specifically union advocates, are bringing up implicit bias in cases and making those sort of arguments. And something that we talked about just really quickly is, that, the concept of implicit bias, specifically amongst white folks, has been, something that people of color have known about and lived with their entire lives, right? And that now, as we're getting to this point where we can actually name it and make that advocacy point, and at least have some concept that other folks, thanks to trainings like this, will understand, and start to explore the concept of implicit bias. That seems like a helpful step forward. So.
Okay. Anybody else want to report out from your groups? It sounds like we were doing a lot of good discussion, but maybe not so much discussing the hypotheticals. So let me go back a little bit to those hypotheticals and give some ideas about them. One notion that I think is significant is that in these cases that I set out for you, the first one, we have a black revamp fired for theft. That may trigger unconscious bias in which Blacks are associated with crime and therefore unconsciously prime a decision maker to think that the person is guilty, especially if the evidence is very close. And then the second case, I was trying to give a scenario in which the stereotype of angry, the angry Black woman stereotype is primed, is triggered. And which could mean that an arbitrator would be more likely to find that a Black woman accused of insubordination, of being too mouthy, if you have it, is guilty. So in other words, one of the ways that implicit bias works is that we talk about stereotype consistent behavior and stereotype inconsistent behavior, and how those two frameworks impact people. And in this case, we have 2 examples of what would be stereotype consistent behavior. not behavior which we explicitly believe that Black people are engaged in more theft or more insubordination than white people, but the subconscious stereotype associating these characteristics or behaviors with people of a particular race. So that's a particular concern, that it is possible that decision makers of all kinds could, in a very close case, in weighing evidence, be influenced by implicit stereotypes. Okay, I did check the chat. I wanted to talk a little bit about decisions that have been, some studies that have been made of judges, because arbitrators are kind of like judges, kind of like rented judges. You know, you pick them from a list and they're paid to resolve your dispute. But there's been not as much research of arbitrators as there have been of judges. And one of my favorite studies was by a guy named Justin Levinson, who's a professor at the University of Hawaii. And if you want any of these studies, by the way, I've got them on PDFs, and just email me and I will, I can send them to you. What Justin Levinson wanted to research was whether, in fact, what, I don't like this term, I'm using it in quotes, model minorities were subject to discrimination, you know, even though they're supposedly minorities who have achieved parity in the world, which is Asians and Jews. And in this study, what he did was he gave the same set of facts to judges, actual judges, but changed the identities of the players. So in other words, where Cohen may have been the plaintiff and Smith the defendant, Smith then gets changed. In other words, this is the name is associated, it's supposed to be associated with Jewish folks, and then Smith, non-Jewish folks, and on the same frame, Chin associated with, you know, Chinese name, changing the identities, keeping the facts the same, but just changing the names. And what they found was that there was significant implicit bias. There were more, the white folks did better off in all of these cases, other than if the arbitrator was Asian or Jewish, in which case there was no implicit bias. So the question really becomes, you know, does this research on judges apply to arbitrators? We know that in terms of racial bias in the judicial system, that it is significant. Here in Oregon, there was a recent study a few years ago of the Multnomah County, the outcomes in Multnomah County Circuit Court here in Portland, where there was very clear evidence of disproportionate outcomes based on race, and particularly Black and brown folks when compared with their white comparators, very clear evidence of race discrimination. And when the court had to deal with that, they went through a very intensive educational process of the judges in implicit bias. And I was part of that, but it really was, you know, a kind of thing where judges in criminal cases have to act very quickly, and which gives time for bias to enter into an equation. We also know that here in Oregon, the belief in implicit bias in the civil system, as well as, I'm sorry, in the criminal system, is not limited to judges, but also extends to juries. And I put the, if you want to screen capture it, I put the site in here where you can actually watch. There's been a new video that has been produced by the Oregon judicial system. It's a new video that talks about implicit bias, implicit racial bias, which is now going to be shown to jurors before they engage in criminal decisions, to remind them to be accounted, to make their decisions more slowly, to be able to articulate a basis for their decision, and other mechanisms to keep implicit bias in check. So we know that here in Oregon, there's a pretty strong consensus that in these decision-making processes for judges and juries, that implicit bias needs to be countered. But what about in arbitration? I'm very interested. I wanted to have people talk about whether you have experienced race or gender discrimination in arbitration. So I'm going to send you back into your breakout groups. This time, I would very much appreciate it so that we can have the discussion. If would be actually stand topic. Have you ever experienced race or gender discrimination in arbitration? It's already been brought out that there are certain people who don't want to engage in the arbitration process due to concerns of how this may make them appear to be. How might that concern be stronger for people of color? Please share your experiences if you feel comfortable, otherwise listen, and we'll come back in about 10 minutes. I'm going to be looking in the chat. Raise your hand. Who would like, anyone would like to share?
Go again. If I'm doing that right or not.
Are you sharing, David? You're on, if you like.
Yeah, I'm learning the technology. I see my little hand pop up there. So in our group, again, we stayed on task, Barbara. You'll be glad to know we stayed on task this time and talked about that. And again, we have 4 people in our group, and the 2 of us with any experience in the process talked about have we witnessed these sort of bias issues in arbitration. And either Donna, who represents public sector folks and has been in cases both as sort of a advocate and also a witness, and myself in both real and imagined arbitration, hadn't seen examples of that, at least bias. In all the years, I probably saw one example of an arbitrator who was showing what I would consider bias against a female agreement in a case. That's a story for another time. But outside of that, that's probably the one instance I saw. And Donna said in her experiences, she hadn't really experienced those issues of sort of bias there too.
Okay, interesting. Interesting. Anyone else from any of the other groups? Can somebody report back? Not at this time. Not seeing any hands. Am I missing anyone?
Well, yeah, and
Sure.
sure. And in a case that I represented years ago when I was the union president, we experienced a case where I felt the arbitrator was biased. It was a racial and gender bias because he did not believe the witness, and he allowed opposing counsel to treat witnesses as hostile witnesses. And it was a case that, in spite of it being final and binding, because we felt we had enough evidence that we didn't get a fair ruling, the District Courts of Appeal originally set aside that arbitrator's ruling because of what we felt was the bias and the treatment of our members who he felt was not credible. And it was an $8 million case. And so he believed management did not mean to give folks an additional $8 million wage settlement, and that the folks who participated in the process were not necessarily being truthful. And so that was one in which we felt the arbitrator was definitely biased for a couple of reasons. And our lawyer later shared with us that oftentimes arbitrators, especially in the public sector, sometimes act as custodians of the public's bank account.
All right, thanks, Sherman. Let me share, let me move on a little bit. We've our own experience. There's not been a lot of research about implicit bias in arbitration. I really could only find 2 sets of studies, both of which focused on gender. And there was remarkably little gender bias found in these arbitration studies. One was the 2006 set of studies of an Academy arbitrators, and the other one was a 2015 study of arbitrators. So although there was an implicit bias found against unmarried mothers, and there were some other correlations that were found, actually the evidence would tend to support the idea that arbitrators are far less biased than either judges or juries. And I think I have some reason why I say that. One of which is that arbitrators are selected by the parties. So if an arbitrator were commonly issuing biased decisions, we assume that the process might have an effect on that arbitrators being chosen. So I think that one of the things that's really, and that we can't say that necessarily about our judges or our juries. We don't really select them. So one of the really positive elements that, and unions do a lot of sharing, and I'm sure management also, with each other. One of the things that I noticed toward the end of my practice was that I actually had, that when I was striking arbitrators from a list, that I almost always got my first or second choice. And that was because I realized that both management and labor, we agreed on who was the fairest of them all from any particular list. But arbitrators, there are vulnerable decision points that implicit bias theory points out. Certainly credibility determination, obviously, we know that white men are assumed to be more competent in an implicit bias manner and subconsciously have an assumption of credibility and of competence that women and people of color have to earn. So, I mean, these are potential, in other words, and also when our arbitrators are striking out in new areas where they may not be handling a situation that they've done before, so they have no guidance from anything. These would be the types of vulnerable situations where implicit bias can put the thumb on the scale for anyone, including arbitrators, because we are human. So what can unions do about bias in the arbitration process, I think, is to be very aware of the notion of stereotype consistent behavior and stereotype inconsistent behavior. So for example, when I was litigating a case as an advocate for a union where I had a person of color accused of theft, who was a cafeteria worker. He was accused of stealing food, and he had also done jail time for, he had a criminal record. And what I did was, when I was litigating it, is I took the issue right on. When I was cross-examining the decision maker for management, I said, are you aware of the fact that so-and-so has a criminal record? Yes, I am. Did you take that factor into account in any manner in your decision? And what happened was it got neutralized because the person said, oh no, And then I also countered I actually used, in my mind, I automatically used the concept of stereotypes. This person happened to be Asian, an incredibly hard worker. And I had him go through, he had memorized his routine of how he cleaned that cafeteria. And he was able to recite a list. So I actually used the stereotype of Asians being hard workers. I mean, I didn't do this consciously. I just realized looking back, I countered the stereotype that this person might be a dishonest criminal with the notion that he was conforming to a hard work ethic that is often attributed to Asians. Thinking about it now, I'm not so sure how I feel about it, but I know that I was aware of the stereotype and aware that I had to do something to counter the depiction so that that would work. I want to talk a little bit about implicit bias in the arbitration selection process. Some of you may know the story of Jay-Z when he was sued over a copyright issue. He had to go to mandatory arbitration, but when he got a list of arbitrators, of the 12 arbitrators he got, none of them were Black men. And it turned out that out of the list that they were doing arbitration from, only 2 of the 200 arbitrators, you do the math, were Black men. And so Jay-Z went to court to get an injunction to try to get out of mandatory arbitration, saying that he couldn't get a fair hearing because of unconscious bias. And I don't actually know how that case worked out, but I do know that it's a very famous case, and that it's a very interesting case because it raises the question about representation in arbitration. We know that the arbitral pool is skewed toward white men. And as a matter of fact, this is a quote from a letter from the president of the National Academy of Arbitrators, which is a very select group of our most prestigious arbitrators in the country, who basically say that the vast majority of our membership is male and white. So 90% of Academy members, the most prestigious members of the Academy, are white, and the majority white men. And that even though they've tried mentorship programs and other membership standards, these initiatives have essentially, admittedly, not succeeded. So what about the idea of racial representation of grievance in the arbitration system? Does a grievant get a shot at getting an arbitrator that looks like them? I just went, this is, by the way, an unscientific review, but I had a little bit of time, and I went through the first 25 names. You'll notice these are alphabetical from the herb list of people that I knew. I felt that I could make a pretty good guess about their race and gender, but obviously I didn't ask them, so this may not be completely accurate. But I do know that Richard Humphreys is the only Black person on the entire herb list. So that would certainly tell me that if I were an African-American grievant, that I would have virtually no hope of getting somebody that looked like me as my arbitrator. And I would view this as a situation of what we might call structural racism. That is not to say that the individuals on this list are racists per se. I actually have used many of these arbitrators. They're terrific arbitrators, and I have felt that they were very fair in their decisions. So, but I do think that when you look at this list, you might think, hey, as most people who look at affirmative action know, or at the diversity efforts know, that the biggest beneficiaries of affirmative action or diversity efforts tend to be white women, and that would be that the data here would certainly show that to be true. So I wanted to bring forward to you to consider this Ray Corollary initiative that's being started by Homer LaRue, who is a professor at Howard, a University Law School. The notion being that advocates tend to choose people that they know and people like themselves. And when people conduct the striking process, you get a list of arbitrators and you strike them, there's no accountability for when you strike somebody from the list. That's a process that's more or less a black box. And we know that appointing agencies in general, I think there may be some difference with AAA, but I know that they don't generally maintain demographic statistics. So because we're using a situation where the membership of the arbitral profession is so dominated by white men, and usually older white men, that grievants cannot expect to have an arbitrator that looks like them. And one of the things that's particularly pernicious is we have this concept called the status quo effect, which is that people tend to not want to take chances in arbitration, and certainly I didn't as an arbitrator. I tended generally to pick people I knew. That process of wanting to pick people maintains the status quo and makes it less likely that someone will take a chance on an arbitrator that doesn't look like them. So again, what the studies do show, though, is that the more people we have from a diverse group in a pool of selection, the more likely it is that a person from a diverse background will be selected. So if you have 2 Black candidates and one white candidate on a list, you really increase the probability that a Black candidate will be selected. Whereas if you only have 1 on your list, it's much less likely that people will select that person. So again, having more diverse people in the pool is likely to result in having more diverse folks selected. So what Professor LaRue suggests, and I believe Alan Simonette, who's his co-conspirator in this process, and there's wonderful work that they're doing. The idea is to expand the Mansfield Rule, which is from Big Law, a concept of hiring lawyers in Big Law, to the selection of ADR neutrals to help overcome implicit biases against diverse neutrals. So with the idea being that if you have at least 2 diverse neutrals on your list, it's much more likely that you will be selecting that person. If there's only 1 diverse candidate on the list, it's very unlikely that they will be selected. So in any event, this is an idea that this expansion of the Mansfield Rule to this Ray Corollary is an initiative that calls for collaboration with lawyers, so that when lawyers select arbitrators, and that's primarily who does it now, is that we will have more of a field, so that we will have more diversity to try to overcome the problem of lack of diversity and systemic racism in the arbitration process. Anyway, that is that's something for unions to think about, because unions do negotiate collective bargaining agreements. And typically part of what's specified in a collective bargaining agreement is how an arbitrator is selected. Sometimes arbitrators are selected from panels, in which case the union has the opportunity to look at your panel. You know, be mindful of whether there is diversity on your panel. If you have a panel of all white people, frankly, with, you know, if you're selecting them from a lot of the lists, that wouldn't be unusual statistically, but perhaps consider whether or not your panel reflects the diversity of the membership. And the second thing might be to consider when you're working with an agency, if it's possible to select a list. And I know AAA can do this. I don't know about the others, but, you know, do something where you're mindful about these choices so that we can give folks of color more of an entree and give our members a higher chance of going to arbitration and not being as afraid that they might not be believed or valued in the way that their peers are. So now is the time for our discussion. We have wonderful arbitrators in our group. They may wish to share, or others, or people. What do you think of this idea of getting at least 2 diverse arbitrators on the list? What do folks think about that? And please raise your hand in the chat, and we can call on you, because we have about another couple of minutes. So I'd be very interested in your thoughts. Yvonne? I see your hand. Yvonne Rivera?
Thank you. Yes, I'm here. I'm here. And you mentioned in the introductory part that in order to be an arbitrator, you must leave your career, you know, and your, you know, basically close all of your commercial, you know, or work relationships to be able to act as an arbiter or arbitrator. And so I think that perhaps, you know, for people, attorneys, you know, it may be difficult to navigate, you know, if you don't have already a capital, to be able to navigate, you know, probably the year, 2, 3 that it may take you to become an arbitrator. So how could you, you know, and I see this in a lot of work, you know, like there's a lot of that is achieved through volunteering, but not everybody has the capacity for really, you know, leaving behind, you know, earning your living to be able to do the work that needs to be done. And so how would, you know, if that is an economic perspective, how could that work? You know, how could it be that in Oregon, there's only one African-American or clearly stated African-American arbitrator, and apparently there's no women, no African-American women who are arbitrators in 2021.
Yeah, it's true. There are none on the ERB list that I know of. Of course, you know, I haven't asked every arbitrator how they identify racially, but that is my understanding. We have very few arbitrators of color on our panels, and I think one of the things that that advocates can do is to try to make an effort, you know, to get beyond the status quo effect and to choose arbitrators of color if you have the opportunity to give those folks work. You don't have to, to be an arbitrator, you just have to give up what you're doing as a labor person or as a management person. You can continue to work if you're, for example, an attorney could continue to do slip and fall cases or other types of litigation. And I think it's a reason, one of the things that was said to me in becoming an arbitrator was, it's going to take you 5 years to be able to survive on your income as an arbitrator. So I waited until I was old enough that I had retirement savings, and I also do other things. You know, I'm a professional diversity trainer, and I do that quite a bit. So I have some other income, but I also realize I might be eating a lot of ramen. So this is a structural problem that arbitrators, who are very thoughtful people in general, in my experience, I've thought about quite a bit. You know, one of the questions that arbitrators have asked themselves in the profession, and I'm happy for the arbitrators here to share that information, is, you know, should they remove the requirement that arbitrators give up their practices as advocates? And, you know, that's something that would be very difficult for me as someone being a labor advocate in the past. I really wouldn't want to pick an arbitrator who was working as a management lawyer. I wouldn't, you know, in other words, and I imagine many management lawyers would not want to pick someone who's working as a union lawyer. So, you know, it's a real quandary. I think one of the various groups have mentoring processes, and I know that there are, you know, many arbitrators I know have been very helpful to me personally, very supportive. There's a lot of mentorship going on, but again, these individual efforts can't overcome these systemic barriers that are so problematic. But I think that Zoom gives us a really amazing opportunity. So long as we're forced to do arbitrations over Zoom, there are more diverse arbitrators in other parts of the country. And we do have some diverse arbitrators on the list. So, you know, we do have some capacity to reach out. I think if people knew that they would be selected. Again, this idea of being able to get more people on the list so that more advocates can be selected, I think it would be creative. It's pretty hard. I mean, if you're sitting in a chair as a person of color and you don't see any arbitrators who are people of color, it's a kind of an environmental message to you that it's not your role. Which is a very unconscious psychological message. So I don't know him. I think that perhaps it's something that the arbitration profession will continue to work on. But I think that it's a matter of also of demand. I think the union movement is very much in charge of the demand. You know, you negotiate what goes into the contracts in terms of how you select arbitrators. So I think that because you know, this idea of the Ray corollary is coming out from Professor LaRue, who's a member of the National Academy of Arbitrators, and Alan Simonette. These are very well-respected Black arbitrators in other parts of the country, and it could be that people, you know, do some research, and, you know, when you create a panel, you know, maybe there's a way to think about including more diverse people on panels. It tends to be lower paying work than other work, but it's a really good place to think about, you know, giving folks a try. And I think that there's just, I know that for myself, I had a pretty significant lack of awareness of this. You know, as a white person, you know, walking through the world, I wasn't as noticing it as much, but I really feel as though for clients, as the union movement includes a larger and larger percentage of people of color, we need to be thinking not necessarily of this generation of arbitrators, but the next generation and the next generation. Because we have a ton of really qualified and awesome advocates, you know, of color in the union movement nationally. And I think it's a question of getting people to be willing to serve as arbitrators and figuring out how can we do it. Should there be grants available? Should there be other mechanisms available? And these are all things that we need to think about. What's most important to me is that we understand that, you know, to the extent that this is a market-driven system, unions are very involved in that market and need to think about what they are going to do as the people who use arbitration services. And by the way, I do want to say that I think that arbitrators have less bias in their decisions than judges because they have more time to reflect. They are directly accountable in that they may not be selected if they show a great deal of bias. And there's a culture of even-handedness and of self-reflection that is really remarkable in the trade. So I am here to say that I actually think that the reason why there have been very few studies on arbitrators and I would like to see a study of race, race discrimination and race. I'd like to see that, not just gender. But I will guess that that there will be less bias in decisions from arbitrators due to their accountability, due to the fact that they have so much time to consider the decision. They have to write the decision down and explain their reasons. And that kind of accountability and transparency, it makes implicit bias less prevalent in the decision-making process, would be my hypothesis. But we do need to think about the systemic racism in the pool. And I think it's something that, you know, I hope that you go look up the Ray Corollary and look up what these esteemed Black arbitrators are doing nationally. See what you can do to support those processes, because the labor movement is very attuned to issues of racism at this time. So I would encourage you to do that and use your market power to make change so that we support arbitrators of color and other arbitrators from diverse backgrounds as much as we do our wonderful cadre of arbitrators that we have on our Oregon list.
Barbara,
Anyway,
there's one final question. I know we're wrapping up and this is it, but how would someone find a bilingual arbitrator? Is that something that they would advertise about themselves on a list?
Well, it's interesting. I think that there are a lot of arbitrators in Spanish that do have a working knowledge of Spanish because so many of the cases involve Spanish-speaking workers. I've noticed that from the cases I've looked at. I think that it would be great if there were, one of the things that we could think about advocating for, that you could think about is, asking the listing organizations if they would include on the bios. Like, for example, recently we know that bios have been altered to include the factor of whether an arbitrator is willing to do a Zoom arbitration. You could say, it'd be really, if it would be helpful to your union, we would like an arbitrator who is bilingual. I'm assuming Spanish, but it could be sign language. It could be, is the fourth biggest language spoken. It would be great if we had that opportunity to really let people feel heard in their own language, if that would be, or at least, you still have some other process, but it would be information that seems that it could be fair to share.
Well, thank you
Any
so
other
much.
comments, questions? Please give me a reaction in your little square. I'm going to give you one. Thank you for listening and for participating. I hope you had a chance to think and learn about a new topic. And I love Lurk. And I appreciate everybody for coming today. I'm going to hang out a little bit afterwards, and I'm willing to say hi to anybody that wants to hang out and say hi. But otherwise, thank you for coming.